not, maybe Mr. Force really. It's the judgment of Nyati versus MEC for health in Gauteng. It's reported in 2008, volume 5, SA 94 CC. The paragraph is 18.
18.
18, my lord.
18, yes.
Yes, and in fact, I would also commend your lordship to look at footnote 9, which is a citation from a US judgment, Pointer Dexter versus Greenhow. There is a evocative paragraph there that they cite about how people that were together in the struggle and when others assume power and responsibility essentially become enemy of liberty. People who once claimed to fight for liberty, once they assume power, contradict the very ideals that inspired the fight for freedom.
Yes.
That's in footnote 9 of Nyati. And then your lordship also asked me where you get the authority to order the suspension. I gave the answer that it is section 172(1)(b of the Constitution. And that has in fact been decided already by Justice Skippers, which was endorsed at the Supreme Court of Appeal. The judgment by Justice Skippers is referred to in several parts of our heads of argument. At paragraph 184 of our heads of argument, we refer to the judgment by Justice Skippers. And particularly, the passage that is relevant is paragraph 84. He starts off by asking, the next question is whether the relief sought that Mr. Motsoeneng should face a disciplinary inquiry and be suspended pending its investigation, pending its finalization, is an appropriate remedy. And then he continues to paragraph 85. The primary duty of courts is to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. And then he says, section 172(1) of the Constitution provides that when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid and may make an order that is just and equitable. And then in paragraph 86, he says, there seems to be no significant difference between an order that is just and equitable in section 172(1)(b) of the Constitution and appropriate relief which a court may grant in section 38 thereof. And then he continues to then say the order for the suspension of Mr. Motsoeneng pending the finalization of the disciplinary hearing is a just and equitable order under section 172(1)(b). It is also an appropriate order under section 38 of the Constitution, in the light of the fact that up until that point, the SABC had itself showed no interest in suspending Mr. Motsoeneng. We would submit that in principle, there is no distinction between that finding and the current order that we ask your lordship to make in this case. The facts are overwhelmingly clear that a suspension with immediate effect is warranted. That concludes then my presentation on prayer 3.1. What then remains is 3.2 and 3.3. Your lordship remembers that those prayers are directed at, once they have been suspended, at imposing a further obligation on the defense force that the remaining members must be told that torture is unacceptable, and the remaining members must be told that if they commit acts of torture, they will face the consequences.
Well, wouldn't that be part of prayer 2?
It would be part of prayer 2. And in fact, what I was going to suggest to your lordship is that prayer 3.2 and prayer 3.3 are interlinked because they are all flowing from the obligation in section 199, subsection 5 of the Constitution. Because that section is the direct constitutional obligation that is imposed on the minister. The security services must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. So there is nothing inventive in the relief that the applicants seek. What they seek to do is simply to enforce section 199 sub 5 of the Constitution. Now, the best argument that has been proffered by the Minister of Defense is to refer us to a document in Annexure NM6 and another document in Annexure NM7, which is a joint operational divisional operative directive to Charlie Company of 21 South African Infantry Battalion.
Yes, I've looked at that.
Dated the 30th of March. We have explained why that document is plainly inadequate to serve the function.
Well, I've looked at it. I think right at the bottom on the last page,
yes,
there's some obscure reference to
yes,
civil rights.
precisely. But there is no reference there to the direct obligation in section 199.5, which is teach the soldiers to uphold the Constitution. What they talk about instead is what we refer to at paragraph 95.1. One, they talk about engaging in battle.
Yes, I know, and that
Yes.
battle without drinking and smoking.
Yes, exactly. Engage in battle, defeat and neutralize the enemy. The morale is high. The Alexandra people don't care about the measures that have been put in place. The Alexandra people are resistant towards the SANDF because in Alexandra, they support illicit activities within Alexandra. In 95.4, they were instructed to channel the non-compliant members and to allow harsh measures of the law to take course.
Just give me the page number there, please.
I'll give you it's volume 3,
Yes,
page 295.
not fine, right.
Yes, at paragraph 22.
Yes, I remember reading that.
Yes, the gap and surface and the concept combined by commanders' core functions concepts will be applied. Foot patrols will be conducted for 24 hours daily. The areas in between could be utilized to channel non-compliant members and to allow harsh measures of the law to take course. Commanders' core functions may be applied to find and fix and neutralize non-compliance, detection, preparation, and maneuvers for response. The language that is used in the very document that they say has been applied, firstly accuses virtually every person they see in Alex as a non-complier. They talk about the morale of the soldiers being high, and they talk about people of Alex supporting illicit activities. And the way to deal with this is to channel non-compliant members and to allow harsh measures of the law to apply. No reference to the Bill of Rights. This is what the minister says is her attempt at complying with section 199 sub 5 of the Constitution. One would have expected the document to comprise all rights that are in the Bill of Rights, to explain how freedom of movement will be observed, to explain how life will be protected, explain how dignity will be protected. But what's clear is that the operational document that they put up is entirely consistent with the attitude adopted by the minister, that we will scope, skid, and donor when the circumstances determine that. So quite clearly, the directive that they have put up, the channeling of non-compliance, the allowing of harsh measures, and the very suspicion that virtually everyone in Alexandra is a non-complier. We cannot be surprised, my Lord, today that Mr. Khosa was treated in the way that he was, because the soldiers were told from the get-go that in Alex they will meet resistance, because in Alex there are non-compliers who are resisting the instructions of the state. They were also told that there will be the commander's functions will be applied to find, to fix, and to neutralize non-compliance. We know for the evidence given by Mr. Nico Tennyson, who says that the language of neutralizing is overcoming an enemy by force. And so there is very little doubt why the soldiers behaved the way they did. It was the direct instruction under Operation Notlela. That is the operation that they called. And they designed Charlie Company in order to enforce compliance. Nowhere did they comply with their obligations under section 199 sub 5 of the Constitution. And so that is why your Lordship is in fact doing the country an immense favor by restating what those obligations are, because the internal instructions in fact, do not do so. What they do is the opposite. The same, my Lord, with the document, another document that we have been given. So the Charlie Company is NM6 starting at 291. And I've referred your Lordship to all of the passages in that document. And your Lordship is right, is that you will have to go to the end of that document to find vague references to the Constitution, whereas in fact constitutional rights should be front and center of this document. Then the second document, and these are the only two documents that have been put up by the Defense Force. The second document is at 315, Annex NM7. This is so-called guidelines for deployed troops. Firstly, it's one page, and nowhere does it talk about the Constitution and the Bill of Rights. It talks in the second passage about the principle of minimum force. It is a laconic statement. General rule, minimum force is always applicable. Minimum force is the amount of force objectively viewed that is necessary to achieve the aim. Nowhere else is there any elucidation of how the soldiers must conduct themselves when they get to Alex, particularly where they have already been told that they will meet a bunch of resistant non-compliers in Alex. Can they beat up someone with their fists? Can they instruct someone to do a frog march? Can they beat someone with the butt of a machine gun? None of those are actually elucidated in any of the two documents that they have. If you then go to the police force affidavits, what they tell us is that all our members know about Section 49 of the Criminal Procedure Act. But that is precisely the problem. Section 49 of the Criminal Procedure Act is not about the use of minimum force, but it is the use of a firearm. In other words, can you shoot or not shoot? What we know is that they have shot at least 9 people. But what we do not know from any guidelines that have been issued by the police is how do they apply or ensure so-called compliance using minimum force. Do you beat someone with your fist, with your machine gun, or how in fact do you do this? So you have a scenario where soldiers are encouraged openly on radio and on television by their minister. Police are encouraged on radio and television by their minister. The actual operational guidelines issued by them simply do not deal with the Bill of Rights at all. They come with vague statements that we've told them to use minimum force, but never actually explaining or unpacking how to deal with the civilian population. Now, in the context where the soldiers have told us in the answering affidavit that we are not trained to deal with the civilian population, we don't know what to do, our job is to neutralize an enemy, it becomes of immense significance that the order that we seek in 3.2 and 3.3 should be granted as part and parcel of the package of relief that we seek in paragraph 2 of the notice of motion. So, my Lord, we have shown that there is a direct constitutional obligation in section 199.5. We have shown that it has been violated in public statements and in conduct. We have shown that the pieces of paper that purport to give effect to it hardly do so. They leave large gaps, and those gaps are the gaps that are used for essentially what is criminal conduct. We have shown that even those documents that have been distributed to the soldiers, they in fact encourage the use of force. And we have shown that the police and the soldiers have no instrument whatsoever teaching them how to exercise the doctrine of minimum force. And an open-ended statement that says we tell our police that they can read Section 49 of the Criminal Procedure Act by themselves is simply not the answer to the case that we put up. So in those circumstances, we would be entitled to the relief in 3.2 and 3.3 of the notice of motion. That takes me to the relief we seek in paragraph 4. Yeah.
Yes,
so that is the issue of section 19.
Yes, I've read the whole story about that debate.
Precisely. Now, Your Lordship, I won't take to what we say, but maybe the correct starting point then is what they say. The Defense Force says Section 19 is inapplicable of the Defense Force Act, completely inapplicable. because you can simply apply Section 18 read together with Section 20. The police say that we have our own code of conduct and our own operational guidelines. But of course, both answers are completely inadequate. Firstly, on the section itself regulates a distinctive feature of this operation, which is called a joint operation. Section 18 does not apply to a joint operation. Section 20 may apply to a joint operation, but it imposes obligations on the soldiers themselves. Section 19, by contrast, imposes obligations on the minister, and it imposes obligations in relation to a joint operation. So that's the first answer to it, is that that section serves a totally different purpose to Section 18 and 19. It itself, in its title, says employment in cooperation with the South African Police Service. And you do not find that in Section 18, and you do not find that in Section 20 either. The section is intended to explain what the Minister of Defense and the Minister of Safety and Security, the Minister of Police, must do when the soldiers are deployed in cooperation with the South African Police Service. So answer number one is that it is no answer to say the role of Section 19 is subsumed in 18 and 19, because the role is distinctive. It is to regulate obligations of the Minister of Defense and the Minister of Police in a joint operation. The second answer to it is that Section 19 gives effect to a constitutional obligation. Now that is in Section 201, sub 2, sub A, which says only the President, as head of the National Executive, may authorize the employment of the Defense Force, A, in cooperation with the Police Service. There is no other provision in the Defense Act that explains how Section 201, sub 2, sub A will be given effect. The only section that explains how that section will be given effect is Section 19. And so if you simply wrote it out of the statute, as the Minister of Defense would wish us to do, there would be no statutory enactment that gives effect to the obligations of the minister in the context where the President has deployed the army in cooperation with the police. That too is understandable. The Defense Force functions differently under Section 200.
I just want to ask something. I haven't got the section here. Section 20, not 20, 201.
Yes.
Does it say National Executive?
Yes, as head of the National Executive.
Yes. Now, where in the Constitution is National Executive defined?
It is in those Section 80 something. Somewhere, it's 91. So that deals with cabinet. Sorry, yes, 85, I think. That is what your Lordship is asking me. 85.1, yes. The executive authority of the Republic is vested in the President. The President exercises executive authority together with other members of the Cabinet by implementing national legislation, and then it continues. Then it talks about the election. And then the Section 91 is then the Cabinet.
Yes, the National Executive is
the Cabinet. Yes.
All the ministers.
All the ministers.
Not any of you.
No, all the ministers. It says the Cabinet consists of the President as head of the Cabinet, a Deputy President, and ministers. The President appoints Deputy President and ministers, assigns their powers and functions, and importantly may dismiss them. And then, yes, so it's Section 91 that talks about the Cabinet, and Section 85 that entrusts the executive authority upon the President. But I want to see whether or not there is any section that deals specifically with the National Executive, because the Constitution seems to deal with the Cabinet.
Yeah.
And Section 201 says the President as head of the National Executive, has certain powers that are to be exercised.
Well, that's why I'm asking.
Yes. Yes.
The National Executive, I couldn't find a definition of it, but it seems to be the cabinet members.
Yes, it's the cabinet members. What's
But I
clear
mean-
is that there is no doubt that the Minister of Police and the Minister
No,
of
what,
Defense.
but why I'm asking this, because the letter from the President refers to the National Executive, if I remember correctly.
Yes, I must just find the letter itself. Yes. My Lord, the letter says, on 23 March 2020, I announced that the National Coronavirus Command Council has decided to enforce a nationwide lockdown for 21 days with effect from midnight, Thursday, 26 March 2020. The decision by the National Coronavirus Command Council was taken as a measure to save South Africans from the infection and to save lives and thousands of people.
So that's not the National Executive.
No, it's not. This command council is a body that they seem to have established, and no one really knows what the legal authority for the National Command Council is. But I think many of us have been concerned about being healthy first before we question who this command council is. Nevertheless, the president is the head of the...
Are you satisfied that the letter in terms of 201 has legal force?
No, my Lord, we've not challenged this,
No.
but it's not clearly not a decision of cabinet. It's a decision of a command council which has no legal authority.
Yeah. Well, it's not dealt with in the affidavits anyway, is it?
No.
No.
No, we have not complained about this part of the case. I mean,
Yeah.
but it is apparent. It's like the curfew. An arbitrary curfew is imposed by a command council, and the command council has no statutory authority at all. The president tells the nation that he's been told by the command council to implement their decision. But the command council, again, has no legal authority whatsoever. Nevertheless, in this particular case, we can assume that the president acted lawfully when he announced the decision of the command council. We may even assume that the president was announcing his own decision, even if he was in agreement with the National Command Council. What he did say is that he was doing so in section 201(2)(a) of the Constitution. What that means, if we look at section 201(2)(a) of the Constitution, is that he was only the president, as head of the national executive, may authorize the employment. And your Lordship is right in asking, why is the president announcing a decision of the National Command Council when the National Command Council has no power in section 201(2) to do anything? It doesn't even exist. The power is assigned exclusively on the president. The Constitution says only the president. Be that as it may, what he did announce was that the Defense Force would be in cooperation with the police service. When it is in cooperation with the police service, we go then to the Act and see what provision regulates the conduct of the minister when the president exercises his power under section 201(2)(a). The only section we find there is section 19. And so section 19 then plays this role of giving effect to section 201(2)(a). It says so itself in section 19(1). The Defense Force may be employed in cooperation with the South African Police Service in terms of section 201(2)(a) of the Constitution in the prevention and combating of crime and maintenance and preservation of law and order within the Republic. And so you get this argument that our learned friends raise for the defense, where they talk about section 18(1) and section 201(2)(a), and they never account for the fact that section 19(1) specifically incorporates section 201(2)(a). It's the statutory enactment of section 201(2)(a). And so they cannot get away from the obligations imposed by section 19. So we know two things then about this section. One is that it gives effect to a constitutional obligation. The second is that it plays a distinctive role which is not covered in Section 18.
Well, if it doesn't apply on the present, to the present situation, what would Section 19 be there for?
Yes, Your Lordship is right. In fact, I'm reminded of the presumption against redundancy or absurdity or superfluity of legislation. One cannot interpret a law so as to render a provision superfluous. One can't interpret a law so as to render a provision redundant. The Minister is urging us to interpret the Defence Act in a way that ultimately renders Section 19 redundant. But the reason, of course, they do so is a factual reason. We pleaded non-compliance with Section 19. In fact, the non-compliance was raised from the very word go in the letter of demand. We pleaded this. Then they responded at page 217, paragraph 35 of their answering affidavit, where they say in paragraph 35 of the answering affidavit, the premise of the applicants is incorrect. Section 19(3)(c) of the Defence Act is not applicable. There is therefore no obligation on me to develop and publish a code of conduct and operational procedures as envisaged in Section 19(3)(c)(1) of the Defence Act in the circumstances. So the factual problem that the Minister faces is that she has not complied with the obligations under Section 19(3). So what then she does then is to put a legal gloss on the factual non-compliance by arguing that the section is inapplicable, when the section on its terms, interpreted through its context, giving effect to constitutional obligations, is clearly applicable. So factually, Your Lordship can accept that it is common cause that the Minister has breached the duty that is imposed by Section 19(3) of the Defence Act. And if Your Lordship accepts that the section is applicable, and in fact there is no basis to allege that the section is inapplicable, then the matter becomes clear. What does the section require the Minister to do? In Section 19(3)(c), the Minister must approve a code of conduct and operational procedures. Not a generic code of conduct that applies to the Army. They've given us about 50 pages of a code of conduct that they say the Army applies. The code of conduct that is required is of a joint operation. The best we have on a joint operation is Operation Notlela, and that one piece of paper. But there is no code of conduct that regulates the conduct of the Army in cooperation with the police. And it is obvious why a code of conduct that is specific to a joint operation is warranted. The soldiers are there in order to protect the territorial sovereignty of the country. The police, on the other hand, are there in order to monitor the conduct of the civilian population. The training methods, we are told, even by the Minister of Defense, are different. Soldiers must neutralize and overcome an enemy by force as soon as possible. On the other hand, police perform a completely different function. If you are going to put both of them to go around the streets of Alex carrying R5s, you have to put a code of conduct and operational procedures to guide the way that they behave. That's not something we've dreamt up. It is imposed by the legislature. Parliament decided.
Who would be in charge of a joint operation?
Yes.
Is it, the ranks are not even the same?
Precisely.
But who would be in charge, do you say?
Well, my lord, there is item 19(3)(c), 2, and BB. So the first obligation is a code of conduct and operational procedures. But the second item, which is also obligatory, is guidelines on coordination of command over and control of members of the Defence Force and the South African Police, as the Chief of the Defence Force and the National Commissioner of the South African Police Service may determine. So on the day they went to Mr. Khosa's house, remember what we've seen on the facts, is that the soldiers were in the back of the car of the JMPD. But they were clearly calling the shots, and the JMPD were watching the assault. And that is to be expected because the statute says you must design guidelines of coordination, of command and control. So the guidelines will then explain that if they are sent on Operation Notlela, who is in command? Who is in charge of the operation? Do they report to the Army? Do they report to the police? But we don't have that at all. and we are now operating in complete darkness.
Well, who would be accountable? Would it be the most senior police officer or the most senior defense force officer? Who would be accountable for any operation?
Well, my lord, it seems that they would have to decide between themselves, because it says, as the chief of the defense force and national commissioner of the police may determine. It seems that what the legislature intended is that they must pass guidelines to decide command and control. So maybe...
As we have it at present, I'm just speaking from memory, as we have it at present, we wouldn't know who is accountable.
No, we have no idea who's accountable at all. We know what the spokesperson told us. The spokesperson said there was complete confusion because we are not doing the same thing as the police.
Yeah.
So, but this is why it's so significant that the minister must comply with Section 19.3, and their argument that we don't have to comply with Section 19.3 makes no sense. That then takes me to Section 20. And your Lordship knows that there is a fundamental mistake that our learned friends commit in conflating Section 19 and 20. The defense says, well, look at Section 20. The police also say, well, look at Section 20. And the police, in their affidavit, quote Section 20, but up to the words police service, and they don't quote A to F. Now, the reason why it's crucial to read the section in its entirety is because Section 20, firstly, does not bind the minister. It imposes no obligation on the minister. It is only Section 19 and 18 which impose obligations on the minister. Section 20 talks about powers and duties of members while being deployed. So this is a section that is directed at members. But most importantly, the powers and duties of the members of the defense force are restricted. They are only those in item A up to item F. In the context of the Police Act, Section 13.3 applies, Section 13.6, Section 13.7, Section 13.8, Section 13.9 of the Police Act. But not the entirety of the Police Act would necessarily come into operation. But even if you applied that, it would still not answer your Lordship's question about how is command and control to be divided between the two, because that is a function served by Section 19, is to precisely divide up command and control between the army and the police. The same thing with Section 9 of the Regulations of Gatherings Act, same thing as the Section 9 and 41 of the Arms and Ammunition Act, Section 11 of the Road Traffic Act, Section 31B of the National Road Traffic Act. None of those sections perform the function that is designated by Section 19. So in reality, Section 19 still serves a distinctive purpose of imposing obligations on the minister, both of police and the defense, in the context of a joint operation. But it also imposes obligations on the chief of the army and the chief of the police service on questions of command and control, so that we avoid the debacle of Alex, of having soldiers in the back of a police car, and where the community doesn't actually know where to complain, where the soldiers are in the back of a police car, and where, in fact, you have the members of the JMPT just watching an assault, because no one can instruct the soldiers, stop the assault, because no one knows whether they have operational command over the conduct of the soldiers. So, it is therefore in those circumstances, my Lord, that we say that it is a common cause that the Section 19.3 has not been complied with. We ask your Lordship to reject the argument that says that the section doesn't have to be complied with. And we ask your Lordship to order. At the time we brought the proceedings, we asked that this should be done by the 1st of May. Now that was, of course, in anticipation of the looming reinforcements. I mean, we now know that at the time, there were 2,800 soldiers, but now there are 78,000 soldiers deployed. But we'll know that they will be around until the 26th of June. So there is more than enough time for the, your Lordship.
What should I say in the place of 1st of May?
Well, my Lord, perhaps we would have to design an order that perhaps says that perhaps within 7 days. I mean, no one knows how long it takes to develop the code of conduct.
Yes, I don't know.
Yes. But, my Lord, a reasonable time would be a period of 7 days. Within 7 days of your Lordship's order, the code of conduct.
Maybe, you know, I don't really know how the administration of the Defence Force works, or the police. And in these times, you know, to expect double speed, if I can use that word, doesn't seem practical.
No, my Lord, but I think 7 days is more than adequate.
I mean, there would have to be consultations and meetings and so forth.
Yes. But my Lord, we are dealing with a scenario where this is an extant obligation. When the operation began, the obligation was present. So they've just conducted themselves. No one knows, did they forget about the section, or did they just deliberately to decide not to comply with it, or did they take legal advice that said the section was inapplicable? No one has given that explanation. And so for them, if they are asking for time, which they have not even done, what they have told your Lordship is that we have no duty to comply with Section 93. If your Lordship...
We'll probably hear an argument later what I should do as far as that point is concerned.
Yes, my Lord. I would say for now, my Lord, that if you gave the Army and the Chief of the Police 7 days to develop this, that would be more than adequate. What we cannot have is another extra day of the utter confusion about operation, non-compliance rather.
Well, what would the content be of this this code? Just very briefly.
Well, my Lord, what we know for sure is what the BB says. I mean, first the AA is cooperation. BB is coordination over command and control, which is what we debated with your Lordship. But the second one is questions about code of conduct. You know, what do you actually do as a member of the JMPD when you are present and you are witnessing misconduct by the Defence Force? Where do you report?
So it's really what you say in paragraph 4.2.1. And
yes, my Lord.
Am I right?
Yes, we do say that as well. But for the joint operation, what's clear is that there will be an overlap of functions between the JMPD in this instance, or the SAPS in a different context, and the Army. And we know that they are regulated differently. So, and the Act says, well, there should be a specifically designed code of conduct and operational procedures. And this Act is in acknowledgement of the problem that we have seen has now borne out by experience. So, my Lord, I have dealt with the expansion of the guidelines, and what the only part to simply emphasize on the guidelines is 4.22 and 2.3 is when your Lordship considers the content of the order. That needs to be crucial, because although we hear open-ended statements that everyone knows that this is about saving lives, and you get Operation Notlela, which says neutralize the enemy, the reality is that it may be that our police and our soldiers have not received proper training about how to respond to COVID. And that is why we've asked specifically that these guidelines must be about the state of disaster, and they must be about the implementation of the lockdown regulations. I mean, we've had no evidence. I mean, they keep on saying we've trained. We've had no evidence whatsoever of any training. We've got one document that says we've given them this document. And you have no evidence of anyone giving the soldiers this document they're talking about. And if they're right that they gave them that document simply encourages more force than the goals of the lockdown. So, I mean, one cannot have a scenario where you have 78,000 soldiers deployed on the streets, told that they should enforce lockdown regulations, and never told how to.
Tell me, this brigade or battalion or whatever it is that is active in Alexandria, how many members are involved in that? Does one know more or less?
Yes, we will have a look at the number of the members. This was, your Lordship will remember that this was when we still had 2,800 soldiers before the reinforcement.
But now does one know?
Yes, but we will check now how many do they say were deployed in Alex. So that then takes me to the next prayer, which is the it dealt with the code of conduct.
Which one is that? 3-5.
Yes, my colleague says that the document simply says it's 3 platoons, but
3 platoons.
I'm not a military person. I don't know how many people are in a platoon.
Oh, I don't know.
And then there is prayer 5 and 6. What I propose doing here, my Lord, is that my learned friend, Mr. Winks, will address the argument on the complaints mechanism. I want to address only the argument on investigation. What we have asked for is that your Lordship should impose a judge to head the investigation. You must take the power out of the bureaucrats and politicians and impose an independent person. Let me explain this, because there is a lot of complaint about separation of powers.
Yes, but there's that Heath case.
Yes.
That they mentioned.
The Heath case says that there are certain commissions that a judge may not participate in, or certain functions that a judge may not participate in, because that infringes judicial independence, because they then become basically a slave of the executive. But the point we make here, my Lord, let me outline this clearly. We have selected a judge as a symbol of 3 attributes: a symbol of independence, a symbol of forensic ability, and a symbol of appearance of impartiality. In other words, public confidence. But there may also be another person who shares those attributes, who may not be a judge. If the objection...
Well, just give me some examples. What do you have in mind?
A senior counsel.
Senior counsel.
Could also be a person. A retired judge, which is what we have selected in this case. The problem is usually with an active judge.
Would you be prepared to take this task?
I think I'll give it to Mr. Maineche. So, my Lord, the former Auditor General, the former Public Protector, there are just so many examples of people that would share the 3 key attributes that are warranted: forensic ability, independence, public confidence. Now, the judge is chosen precisely because they hold those attributes. There is no complaint that those are the necessary attributes in order for this investigation to be carried out. What we get from the respondents, one is that we have IPID. Now, in the papers, your Lordship has seen the problem that we point towards IPID. IPID published an annual report in 2019. They said 4 things in that annual report which impair their independence. Firstly, they said they are counter-investigated by the police that they are meant to investigate. So they initiate an investigation and the police initiate a counter-investigation. They said, secondly, they are infiltrated by the police, so the police have got their own spies in IPID. Thirdly, they said they have no money because the money is not given to them to fill positions. They have no money, the money is not given to them to conduct operations and investigations.
Yes, I know the whole story. No money, no personnel, and so forth.
Precisely, my Lord. And then they said they are constantly undermined by the minister. There is political interference.
Yes, but then they say it's going to be even worse if you take 10 of their members away to do this task.
Yes, my Lord. That's what they claim, that the restrictions on their own personnel. But then, of course, the independent investigator can have different personnel. It does not have to have personnel seconded from IPID. It could have completely different personnel. If IPID says we don't want to contribute our own members to an independent function presided over by a judge, it could be different people. But the idea, and this is the crucial argument we try to persuade your lordship about, the idea that IPID must undertake this function in circumstances where IPID tells us that it is infiltrated by spies of the police, that it is constantly undermined by the police, that its independence is infringed by lack of resources and political interference, simply is neither just nor equitable in these circumstances. That's point number one. IPID has told us that they have no independence. The problem, the police keep on referring to IPID and the defense keep on referring to IPID, that is utterly irrelevant because IPID itself has confirmed on oath that the report of 2019 is the correct statement of their position. What they complain about is that do not deplete us further. What they complain about is that give us more resources. What they say in the affidavit is that we should have asked your lordship to order the allocation to be given to IPID.
You know what bothers me about this, Mr. Khosa, this, let me see which player is it again. Oh, yes, player 6. You know, obviously I know what the respondents say. And amongst others, there are mechanisms in place. The only point is that they are either not performed to you know, say your, I mean, you know, objectively speaking, to the applicant's satisfaction nor yours, and perhaps not mine either. But nothing would stand in your way of bringing an application, urgent application, saying that there's an investigation allegedly taking place into the death of Mr. Khosa and so forth. There's been a delay of a month. We have no answer from anybody. We have no firm commitment. We've been giving various versions as to what will be done by whom, and asked the court for a mandamus to direct that the report be completed within a week and handed to the same judge hearing the case.
Yes.
I mean, wouldn't that be the best practical way to do it?
Your Lordship, I would accept that in ordinary circumstances, but no one can argue that this is an ordinary case.
No, but you can draft that application and bring it on Friday.
Before your Lordship?
Before me. I'm on duty this week. I don't know what I'll do with it, but I mean, I'm just saying it can be done.
Can I explain the two problems? Why even that will not be just an equitable?
Yeah, tell me that.
The one is that does not answer one of the key problems we've put in this application, which is that there is no joint jurisdiction. No one has joint jurisdiction. IPID has jurisdiction only over the police. The defense only have jurisdiction over the...
No, but you cite the defense force, and we know that they were defense force members.
No, we do, precisely.
And, in that envisaged mandamus application. And you cite the police because the police were there.
Yes, no, I accept that. That is theoretically possible. But we could never get an order compelling IPID to investigate the soldiers. Nor could we ever get an order compelling the soldiers.
I'm not saying that. I'm saying you can compel the police within their mechanisms that are available to do what they need to do, and the same with the defense force.
My Lord, what we know for sure today as we speak, and which is why the order that your Lordship has in mind, I accept the practicality of it, but which is why it's not just an equitable on the facts of this case. What we know for sure today is the defense, through its board of inquiry, did not conduct an independent inquiry.
No, I know that, but I mean, now you're going to get an order from the court, say, for argument's sake.
Yes. And
then they will be ordered that this report that's now floating around the defense force somewhere will be completed and produced to this court within a week.
Yes. But I wonder whether I'll address your Lordship on that particular point. We'll take advisement on that issue. It could be that if a case is made out properly on these papers, we amend the notice of motion.
Yeah.
In other words, instead of asking for prayer 6 on those terms, we amend the notice of motion on the terms that your Lordship has asked for.
Yes, as long as nobody's prejudiced, I mean, the rules make provision for that.
Yes, no, precisely, because the one...
And you can have a look at the case of Eke, spelled E-K-E versus Parsons,
Yes.
of the Constitutional Court, that says that under certain circumstances a court can fashion new rules that would ensure justice to the case if rules of court do not cater for any specific...
Yes, precisely. It could be that perhaps the answer, I mean, I appreciate fully your Lordship's concern. It could be that the answer, in fact, is to amend paragraph 6 and that ask precisely for the relief that you seek, so that it's part and parcel of the same case.
That, I haven't decided this case. I hope I don't give that impression. But I think it's my duty to put to you what problems I will have when I start writing my judgment.
Yes, yes.
And then, I may well say to myself, there are other mechanisms, there are other avenues, and then, it's worthwhile debating that in court.
Yes, yes. I mean, I put only 2 proposals in response right now on my feet. The one is that your Lordship...
In the evening tonight, there may well be discussions taking place between you and the Defence Force to the effect that I'll be given the report before Friday.
Yes. Well, you heard what my learned friend had to say.
Sometimes after a day in court, people will reconsider previous...
But hopefully the clients are also watching.
Previous... When?
That's what I was facing.
Yeah. Well, I'm glad to hear, because that's one thing that really bothered me.
The SANDF is playing open cards.
Yeah, well, we'll get to you, Mr. Manetti, but I mean, thank you for saying that. It makes your colleagues' task easier and mine.
Yes, my Lord.
And for the sake of the public, there needs to be trust and there needs to be confidence, as I said in my introductory moralizing speech that I normally give in court, as Mr. Bifalatos will know.
Yes. Thank you, my Lord. I mean, it's obviously somewhat comforting that we have now a promise from the equivocation that we will get the report. Whether we'll get it this year or next year is still an open question.
No, he said before Friday.
Yes.
This year.
Yes. So that I accept, my Lord. What I am suggesting now is that it could be that the case is fully pleaded and that the relief that is competent in place of paragraph 6 is that there should be a report produced.
Yeah.
What that still does not answer, my Lord, is that it answers one aspect of the case, which is the report by the Defence Force.
Right.
What it doesn't answer is the IPID report, which is completed.
Well, where is that?
Well, IPID investigation is completed. It's over. Because they told us...
No, but they didn't tell us what they did.
No, they did, my Lord.
No, but they said they interviewed people.
Yes, and then
they came to a certain conclusion.
Yes, and then
the police were not involved.
Precisely, yeah. So...
But I mean, where's the actual finding?
Nothing. The best that they told us, I mean, that's why this IPID investigation is a complete sham. Because in page 688, that is where they tell us what their conclusion is. They went around, they spoke to 5 people. They say that the police watched the assault, and then they say we decided, therefore, not to open an investigation.
Well, surely there must have been a document that says we did the following. We went to A, B, C, and D, and we interviewed so-and-so, and we were told X, Y, and Z, and we investigated, and then we came to the following conclusion.
Yes.
Something like that must exist in writing or not.
Yes, but we have, I mean, we know what they say in writing, because if your Lordship looks at, in paragraph 28.4, so they say Mr. Khosa advised me that so they had these 2 investigators who communicated to him on WhatsApp, and they went to Alex and they met with the family of Collins Khosa, and then they sent the copy of the WhatsApp messages.
Yeah.
And then we know the WhatsApp messages. And then once I got the WhatsApp messages, I closed the investigation. And
Mr. Khosa Toby, in the light of your colleague's promise, to which I will hold him, that we will get the Defence Force report. It may be also advisable tonight when you think about the case to amend Prayer 6.
Yes, indeed. I will amend
You know,
Prayer 6.
if on the basis of courts that nobody is prejudiced.
Yes, indeed.
But it's unlikely that they would be.
No, indeed, my Lord. What we will be amending is to look for lesser relief.
To lesser relief,
Yes,
exactly.
not more relief.
Yeah.
So the only issue that remains, I mean, no one knows how the defense, but we'll think about how the defense force, what remains really is that IPID has done a shoddy job, and it has not lived up to the expectation of independence. The question that your Lordship then faces in those circumstances is what is just and equitable to do in relation to the fact that IPID has covered up a crime?
Yeah.
What would be an appropriate relief to make sure that those police officers who watched the crime being committed are also brought to book?
And what do you say what that would be?
We would have to think about an appropriate order
Yes.
in place of what we have suggested.
Yes, will you do that?
Precisely. So your Lordship knows the point we make about IPID.
Right.
Your Lordship also knows the point we make about the fact that this was a criminal cover-up based on S versus Governor, and I don't want to go beyond that. And then your Lordship also hears from the military ombud. But your Lordship, we've conducted a full assessment of the military ombud. And it's clear that although there is a promise of independence, that promise of independence is not carried out in the legislation. Firstly, the ombud himself is a retired army general. It's the generals.
I've read all that. We
Yes.
don't have to go into that again.
Precisely. And so there can be no debate that the...
I mean, the Ombudsman is not opposing this application.
Well, this is the problem, my Lord, is that the Ombudsman first says, I'm giving an explanatory affidavit, and then they put in heads of argument that say the relief shouldn't be
the point
granted.
is, I'm not quite sure whether I'm going to allow that. You know, I remember what I did in the about 2010,
Yes.
where RAF, the Law Society, brought an application against the Minister of Transport.
Yes.
And all types of parties wanted to intervene at the last moment and filed affidavits and heads of argument, and then even wanted a postponement. And what I ruled was that I would admit their affidavits and I would consider them, but I would not grant a postponement, nor would I grant an oral argument.
It could be that both in relation to IPID and the Ombudsman.
And that's what I actually had in mind as far as that's concerned.
That's salutary, because they can't tell us yesterday they're not opposing, and then at the last minute file extensive argument opposing. Well, in that event then, my Lord, that makes my job much easier than it was in relation to paragraph 6.
Yeah.
That concludes my submissions, and we submit that even if your Lordship granted the declarator any relief we asked for in the notice of motion, we would have been substantially successful, even if paragraph 6 is granted in lesser form than it currently is, and we would therefore be entitled to our costs. We are litigating against the state.
Yes.
Whatever happens, we are not liable for the costs. Thank you.
Have you got any comment about the intervening party or not?
No, my Lord, we would like the intervening party to be allowed to intervene. We support their application.
Yes, I don't. So you've
Lord,
got no other comment?
I have nothing to say.
No.
In relation to the amicus has already been admitted by
Yeah.
Justice Colapen.
Yes, but the same with the amicus, I will only I will allow the affidavit, but I'm not going to allow any oral argument.
Yes, my Lord, I don't want to say we support their right to make oral arguments, because your Lordship has already told me your Lordship's position.
Well, it's not necessary, and we'll delay the matter further.
Thank you, my Lord. Well, then, my learned friend will then deal with the complaints mechanism and an international law angle to the case.
Yes, thank you. Is that Mr. Wilson?
This is, no, Mr. Winks.
Mr. Wick, sorry.
Yes.
What refers to prayer?
And you know, it's all over the show.
Which prayer?
As the court pleases, the international law aspects pertain mostly to prayer 5, but also it overlaps to an extent with prayer 6, because the complaints mechanism and investigation mechanism have to work hand in hand.
Mr. Wicks, for the same reason, not the same reason, but a connected reason that we need to save some time. Look, I've read the whole story about the international documents. And there's very little point in, quoting it to me again or reading it to me again. I will keep them in mind, unless there's something, really crucial that you like to point out.
As the court pleases, there are just 2 points that I would make that haven't been made perhaps amply in our heads of argument.
Yeah.
The first is essentially a point at the beginning, and the other is a point at the end of our discourse on international law. The first point is an elaboration on the judgment of the Constitutional Court in Glenister 2,
Yes.
where it was held that it is not simply the court, in that case, enforcing standards, directing the state to inject certain standards, safeguards of independence of an independent corruption fighting agency into the law, into the institutional design. The court held that this was not a matter of enforcing the international agreements against the state.
Yeah.
It was about enforcing the rights that are infringed by the failure to create an independent anti-corruption body. So the source of the court's power, the legal basis of the relief, was actually Section 7.2 of the Constitution, which is the state's duty to respect, protect, promote, and fulfill the rights in the Bill of Rights. The rights in that case that were eroded by corruption were
in the
rights.
light of the fact that we are probably getting amendments tomorrow to the prayers, I wonder whether it's really worthwhile going on with that argument now. If I can give you an opportunity later on.
As the court pleases.
It may be more efficient to do it that way.
That certainly makes sense.
I don't want to say that you've got nothing to say, but let's see what comes up by way of amendment, and then we'll look at it and see how it covers your concerns, and then I will give you an opportunity again.
Indeed, my lord. As the court pleases.
Thank you.
Sorry, my lord, my leader just wants to revert on your question about the national executive and where that's located in the Constitution.
Yes.
It's in the title of Chapter 5 of the Constitution, which commences at Section 83.
83.
The title of the chapter is the President and National Executive.
Yes.
And then the provisions deal with President, Deputy President, and Cabinet. So it appears that those are the components of the National Executive.
Right. I'll have a look at that. Thank you.
As the court pleases.
Right, who's next in line?
Well, I would be coming after my friend Mr. Lukai. We discussed earlier that it might be more efficient if the interview stands up, so that when we respond, we respond to both the application and the intervention application as the respondents. And that would, from our perspective, be more efficient because we can consolidate the points that they respond.
Yeah. We can do that. Yeah, Ms. Hassan, can I just tell you what my problems are up front? Let me just get my glasses here. I've got just a moment. again, but now the notice appears. Where in this bundle of heads that I was given are your heads?
Lord, our heads are, you would ask me which bundle. Lord, that I can't answer. I'm not sure that I didn't know there was a bundle of heads. But there were two sets of heads that were filed. There was sets of heads that were filed just before lunch yesterday. And a later set of heads were delivered at about, I'm told, early evening yesterday.
When?
Early evening, Your Lordship.
Yes, I haven't seen those.
But, my Lord, there is a set of heads that were delivered. I'm not sure. I didn't know they were patriotic.
Whatever happened there, I haven't seen those heads.
My Lord, maybe. Lord, I'm going to ask one of my juniors to assist me.
Just a moment, let me just look in the other file here. Just give me a second. Now the problem is that during the course of, from Friday onwards, I and my secretary received documents in various applications about every half an hour. And then every 2 hours, boxes of papers were delivered to my stoep. And then
Lord,
one attorney even said to me, I'm probably going to get a heart attack. But I've been around too long, I don't get heart attacks.
Lord, that I believe.
Let me just look, there's another bundle. Just give me a moment, let me just find
Lord,
it.
I'm told it's page 218 of the heads of argument bundle.
$218, yes. No, just a moment. Is that now the one titled Amicus Curiae? Is that the one?
No, my Lord, I act on behalf of, my Lord, it's written submissions on behalf of the intervening applicants, my Lord.
So then I haven't got the right page.
My Lord, may I?
Oh wait, here's another one. Is that page 239, titled Submissions on behalf of intervening applicants?
As the Lord should please.
That would be the Fair and Equitable Society.
That's correct, my Lord.
Now just a moment, let me just write this down, page 239. Yes, just a second. No, I did read those, and let me just see. Oh yes, but this is what I wanted to put to you. In the fourth and fifth respondents' heads of argument, at page 135 of that bundle. Have you got a bundle like that or not? Paragraph 9.
The Lordship will just assist mine is not paginated.
Now this, if you can just find the fourth and fifth
Yes, my Lord.
heads.
Lord, I have them in paragraph number, if I may.
Paragraph 9. In my explanation in black in the right hand top corner is 135.
I have paragraph 9, my Lord.
Right, now there they said, does that refer to you?
Yes.
The intervening part.
Yes, my Lord, that I
Now
believe
they
that.
say, and this is what I wanted to put to you. You're not entitled to intervene because the issues are different. So the facts are different, the relief sought is different. You failed to demonstrate the direct and substantial interest, and then also that the application is not urgent. Now those are the objections and that I want you to concentrate on. And the first one would be if you could address me on urgency, please.
My Lord,
And can I just tell you what my problem is? If I remember your affidavit, and you must remember when I sit here, as you would have noticed, I don't open court files and I don't look at affidavits, and I just speak from memory. But you, in your founding affidavit, rely on 3 different persons who were ill-treated or assaulted or tortured, or all of the above.
my Lord,
And one of the objections is that nothing prevented you in the past or even now or in future to bring a separate application in respect of those persons and seek the appropriate relief, whatever it is. And you are unjustifiably climbing on the back of Mr. Khosa's application. And that was after you waited a month to bring this application to see what happened to theirs. So the point of urgency is, as I've always said in the urgent court, and for some reason or other, I do more urgent than any other person I can think of. I'm not complaining, by the way, I'm just mentioning it. I always say to counsel at roll call, and you will probably know about that, if you don't need an order now or this week, don't come to me, please.
as your Lordship please.
And the point is, you don't need an order now or this week in respect of those persons. You can draft your application in due course.
My Lord, we submit to your Lordship that the reason the applicants contend that we should come in sometime in the future, my Lord, is because they misconceive what the test for intervention is. Lord, there are 2 tests. The one is the substantial interest, and together with that, my Lord, goes the question of prejudice. But, my Lord, what is mentioned, my Lord, in the papers, but then it seems to have been ignored, is that there's a second basis on which a party can intervene. And, my Lord, that is where, my Lord, the authorities, my Lord, are captured in Erasmus. My Lord, I still have my very old copy, that's the only one I have at home. And that's the commentary on Rule 12, my Lord, and it is the following. There's another basis, and that is the right to relief is dependent upon the determination of substantially the same question of law or fact. My Lord, what is the question of law and fact here? My Lord, the Khosa application, as well as this application, my Lord, challenge the measures, or before we get to the measures, my Lord, they ask your Lordship to rule on the constitutionality of certain conduct. My Lord, we know that the allegations of violence have been made in this application. They've been made in the context of this state of disaster, my Lord, in the applicant's affidavit as well. My Lord, the questions of fact are similar. My Lord, the question of law arise out of the constitutional obligations and the failure of those obligations, the failure to comply with those obligations by the state, my Lord. What the intervening applicant says to your Lordship in the founding papers is that we brought the application, we withdrew it, we were advised to do so for whatever reason. My Lord, they then were told that there was an application for direct access to the Constitutional Court, and they waited. And the explanation they give, my Lord, with your Lordship, is a sound reason. The issues they say, which the Constitutional Court would have had to grapple with, would have been the same issues that this court would have had to grapple with. And Lord, in those circumstances, it was not wise to have pursued similar legal issues in two different fora, especially where the one was receiving the attention of the apex court. Lord, that's the explanation. What they also say to your Lordship is they intended to bring the application. They then heard about the application of the Constitutional Court. They intended to intervene in that application when they were told that the application for direct access had been dismissed. My Lord, if your Lordship were to find, as we submit your Lordship should, that the issues here concern not this particular organization, my Lord, but what the impact will be on those in whose interest it comes to court. My Lord, the allegations are right, my Lord. If this matter were to be heard in the normal course, we are looking at a hearing probably, my Lord, very late in the year, or maybe even next year. My Lord, there is, by that time, the relief sought would be academic. What we do know, my Lord.
So by that time you would have had a judgment from me in the Khosa case.
My Lord, that might be so, but your Lordship will bear in mind that what we seek in this case is slightly different from the Khosa case. One of the things that...
Yes, exactly. Well, that's one of the objectives.
My Lord, I have yet to come across authority which says that once you intervene in the proceedings, that your relief that you seek must be exactly the same as that sought by the main applicant. Lord, if that were the case, then the law would have said that. But what the authorities say is substantially, not the same questions of law, in fact, substantially.
Yes.
And if your Lordship were to accept that there has been unlawful conduct which warrants a declaration, my Lord, then with respect, my Lord, the application is urgent. And my Lord, what you find in the papers of the Defence Force as well as the South African Police Service is, my Lord, they concede that a declarator is not inappropriate. But they say you've not proved the facts. So, my Lord, what they're saying is if you have proved the facts, and we're still trying to understand why they say we haven't proved the facts. If you have proved the facts, then you're entitled to a declarator that the conduct is unconstitutional. And my Lord, in the light of that concession, my Lord, it is difficult to understand how the respondents can continue to resist an application based on the sole basis of urgency, my Lord.
Well, they say amongst others, that's why I referred you to the pages here, starting at 137, and it goes on until and those are the ones that you have to answer. Up to 148, they say that the law is different, the facts are different. You didn't make out a case for a direct and substantial interest. You don't associate yourself with the relief sought in the Khosa case. You should have instituted a separate application. You waited to tag along. And that's as far as the intervention is concerned. And as far as urgency is concerned, that starts at page 144. Where they quote the practice manual, we don't need to deal with it, we know what that is. And then they say you launched an application 1st of April, and then that was withdrawn. It's now a month later, and then what makes it even worse, and that's something that bothers me as well, which I seldom allow, if ever, that you gave them 1 day to file an answering affidavit. Page 146.
Yeah.
And that is grossly unreasonable and abuse of the court process. So those are the questions that you have to answer.
My Lord, may I deal with the second question first, my Lord?
Well, I think the first thing we must deal with is the urgency, because if it's not urgent, there's no point in dealing with anything else.
My Lord, what I submit to your Lordship is it doesn't help repeating the same submission, but what I submit to your Lordship is that if your Lordship were to accept that there are sufficient allegations which point to unlawful conduct, my Lord, then your Lordship has to make an order that the conduct
in
is
respect of 3 other persons.
I beg your pardon, my
In
Lord?
respect of 3 other persons.
My Lord, this relief is not being claimed for only these 3 people, my Lord. They say to you, my Lord, we come in terms of section 38D, my Lord. But it's not these specific individuals seeking relief, my Lord. The relief which is being sought, my Lord, is for the benefit. Lord, in constitutional litigation, there is the principle that, ideally speaking, and I read to your Lordship from the Bill of Rights by Ian Curry and Johan de Waal.
Yes.
Ideally speaking, a court order must not only afford effective relief for the successful litigant, but also to all similarly situated people. This is a second factor that must be considered. There is a wider public dimension. Now, my Lord, if we look at what the relief is that's claimed, and the respondents, my Lord, misconstrue a substantial portion of the relief. My Lord, for instance, if I may take your Lordship to this paragraph, which the prayer, my Lord, may I take your Lordship to prayer 6 and prayer 7?
Yes.
And that's at page 4 of the notice of motion. Both the South African National Defence Force, my Lord, and South African Police Services construe this relief as a suspension of the member or a dismissal, at least a suspension. But what is it that this applicant asks for? They want, once there's been a complaint, perhaps I should read it, the people in South African National Defence Force, upon receiving a complaint or becoming aware of use by a member of the South African National Defence Force of persons who have allegedly contravened the lockdown regulations, regardless of whether such abuse takes the form of violence or intimidation, must forthwith take steps to have the said member removed and debarred from performing any sort of policing or other duties which may expose members of the public to such a member pending the finalization of an investigation and or criminal and or disciplinary proceedings. Now, my Lord, that relief is not only for the benefit of these actors. And why is it that these victims, my Lord, if I may call them that, why is it that the applicant says they should be removed? And there is an ongoing, my Lord, violation. A good example is the case of Mr. Khosa. Lord, what happened to him is he, on the 2nd of April, my Lord, a rubber bullet was fired at him and he was wounded. On the 6th of April, 4 days later, my Lord, 4 members of the police service arrived and they instruct him to undress the wound. They instruct him to go to bed. Well, they want to undress the wound so they can inspect it. You know. When he said to them the doctor had instructed him not to do so, the Lord, they then leave. And he says, I'm fearful for my life as a result of initial assault and subsequent intimidation I have suffered in the hands, the active hands of the members of the South African National Defence Force. My Lord, one cannot have, with respect, my Lord, the public exposed to members who have been accused of having employed heavy-handed tactics. My Lord, we say you've got to remove them. And what is the response of the police that we are going to do? My Lord, they say we can't suspend them because it's not in accordance with the regulations dealing with disciplinary powers, disciplinary proceedings. So, my Lord, there isn't a defense to it. In light of that, my Lord, with respect, and your Lordship has a discretion. And this is one of those cases where, my Lord, this party is coming, this intervening applicant is coming to court and saying, for the interest of this society, we need the court to assist. Lord, this relief is not being changed by the act, by the main act. Lord, if your Lordship were to refuse the application for leave to intervene, your Lordship, with respect, is allowing the South African National Defence Force and the South African Police Services, who have been terrorizing people in Alexandra, to continue to do so. And the Lord, with respect, that cannot be in the interest of justice. We have here a not one, not two, not three, my Lord, violations. My Lord, the papers are littered with it. And
Mr. Ashton, you know, it sounds a bit strange to tell a court that I find that you haven't complied with any rule of court relating to urgency, and therefore allow violence on innocent citizens.
the Lord,
You know, the one doesn't follow the other.
the Lord, that's the impression that goes on.
No, I don't think so.
The Lord, what we know is that these law enforcement officers, my Lord, the Lordship is told on these papers that they've been instructed not to do it. When told, after they've done it, they've been asked to cease the conduct, and they continue. The Lord, will the individuals out in Alexandra and all over the country, the Lord, will they receive substantial redress at the hearing in due course is the question to the flood. And the Lord, people are going to be subjected to violence and intimidation, the Lord. We might have one or two or three or several others before that. Lord, and then we will not be substantial redress at the hearing.
Now what about the urgency aspect?
Lord, the Lord,
Well, the Lehman Neville's case says that if we deviate from the time period set down, we need to explain why and how that came about.
the Lord, what we tell you,
And you know also, if there is a deviation, as you know, it must be released one. Now the parties one day to file an answer application.
the
And
Lord,
everybody's concerned with that, including myself.
the Lord, what happens, your Lordship should look at the matter in context. The application gets dismissed by the Constitution. The application for direct access by Mr. Khosa gets dismissed on Friday. On the Sunday, on the Saturday, my Lord, the application is launched
That's about
for
a month.
hearing on the Tuesday.
That's about a month ago.
My Lord, I submitted to your Lordship. It's not going to help for me to... What we explain to your Lordship, that's the explanation, my Lord. It doesn't get better, it doesn't get worse.
Yes.
They waited for the Khosa application to get disposed of by the Constitutional Court. My Lord, when it was disposed of there, and they heard about it, because, my Lord, at that stage, when that application was dismissed, if they were to come to court on the Friday, they would have had to come to court on the Tuesday. It would be a first, and, Lord, we were in the middle of a lockdown. when the Khosa application is launched on the Friday, I believe not, on the Saturday, my lord, and they come to know their application, they prepare an intervention application which is then served on the Monday. The application is enrolled for the Tuesday. So, my lord, in those circumstances, your lordship should consider why it is that the applicant waited. And after having waited, my lord, and there's no reason for your lordship to disbelieve what they said here. They said, we want to intervene. My lord, if they had brought a separate application, I would not be standing attempting to persuade the lord. But they're seeking to intervene in a matter which concerns, which has in dispute the same or substantially the same issues of practical law.
Yes.
The Lord, the respondents are given 1 day to file papers, but they were given a little bit more than 1 day by the main applicant. My lord, they were not even able to meet that deadline. The result was, my lord, they were given an extension of time to file the affidavit to the main application, and they were allowed an extension of time to file affidavit in the intervening application. My lord, and it was quite evident that regardless of whether this application was served on the Saturday or the Sunday, the respondents were very clear that they were not in a position to deal with all the affidavits. They were able to deal in the response to the main application on the Friday afternoon, my lord, and they would then prepare an affidavit opposing this application. Lord, regardless of whether this application was launched on Saturday or the Sunday or the Monday, the respondent would not have been able to file it. Lord, but there's another aspect the Lord is very near. This application, my Lord, is not voluminous. The factual allegations that had to be dealt with, my Lord, were really the allegations by those individuals that suffered at the hands of the South African police on the 1st to the 4th of April. Lord, and what is interesting is that the respondents don't dispute those facts. The entire affidavit, entire answering affidavit, my Lord, consists of arguments. That's all it is. Lord, the facts were there, and it chose not to deal with them, my Lord, with your Lordship, in the face of the common cause facts, my Lord. Your Lordship should exercise your Lordship's discretion in favor of the intervening applicants, my Lord, and allow the applicants to intervene and participate in proceedings where substantially the same questions of law and fact arise, my Lord. Not the same, because that is not the case, my Lord. And we're not relying on a direct and substantial interest.
Right, now we know what your case is. Is that what these, on these two topics?
My Lord, those are my
intervention and evidence.
on these topics.
Right, and I will hear Mr. Manetti and see what he has to say about that. Mr. Manetti, just a minute, I think you're right down. You are for numbers, respondent 1, 2, and 3. Just going to say that again. Just give me your name again. Mr. Wilson, yes, and you are for the Amity. Yes.
overall, which is what concerned with our business. And then very relation to that, and it's relevant to the exchange we had for our my learned friend, my learned friend, specifically related to institutions were charged with investigating the answer to this commission set out why, as an act of law, an institution can't actually investigate the illicit violence under the law. We were going to consider the consequences of our business rights to be satisfied with amended change
Wilson, as I said previously, I've done that before in previous proceedings. This part I also went to the SCA and I think even the Concord, and it is now to be in order to adopt that procedure. As I've said, I will consider your argument, your written argument. Thank you, Mr. Wilson. Right, Mr. Manetti, now you know what to address amongst others on these topics and in your own case. You are for the first three. The first two. First three, yes, exactly. Just a moment, let me just find your head. Do you want to start off that with the intervening parties argument? Well, on urgency and the legal interest and so forth. Right, I've got that. Page 40. Just a second. That's page 119. Is your volume taken out of that? Well, you can just mark down, you can write down there that it's section D, case application, that's page 119. Makes it easier for you. Right, when you say it's not urgent, you just tell me. Yes.
Waiting for the article general review from the same section as part of the motion where we're asking that they violate the president. And they start to make general broad allegations about incidents of violence. And what the respondent said is violence. And violence is what details
Am I right if I remember that none of those incidents were reported?
None of them were reported.
Yes.
That was a complaint that was responding to. And he hasn't reported the incident.
Not even until today.
That means,
Not even until today.
today they are not. what we think we have done was, having received the answer in our building, and advised the state court to draw the application, and then went to the central spaces that they put in the court. So when we found the case, instead of reporting them to authorities, they waited from the 6th or 7th of April when they obtained those applications, just the days when those applications were signed. They waited for the court application to sign. Now, if they take the head of the court application that they have to constitute, then they want to take on to that, waiting for that to be court. When it was the nine taxes was key, and the court application was now made to the High Court, but then what to follow that to? And they only wrote the application on the 27th of April. From the 6th to the 7th of April, after receiving the two waited until the 27th of April. And they don't explain why they have not reported to the authorities that nine should be necessary. And the important distinction between their application and the court application they are not asking for the court to fashion new complaint mechanisms and new investigative mechanisms contrary to the court application. So they are coming to court simply for declaratives, and then they ask for a string of interdictory relief to ask the SANDF to do what it's already doing. For example, wear your name tags, which the SANDF is currently doing. Don't wear balaclavas, which the SANDF doesn't wear. They only wear masks like we all doing in court. So there is no credible explanation other than that they were waiting for somebody else who could justify agency to approach the courts and they would take up. That's the long and short of their explanation. And as we submitted in the papers, they asked for a relief that is completely different from the relief that we...
Well, Ms. Hassan said that all that I need to look at is substantially the same.
But the substantially is, they asked for 14 orders. The only order that is substantially the same is private thing. The rest they are asking for all sorts of operational instructions that they want issued against either the SANDF or the other law enforcement agencies, which have no relation at all to the kinds of orders that the court applicant has. Even at the level of principle, they say that they are satisfied that the ministers have condemned the acts of any allegations of violence by the ministers. So they're not coming to court saying we have no trust in the existing agencies, we have no trust in the ministers, put in place a new mechanism to investigate these complaints, and we're not reporting them until we have a new mechanism. And with great respect, they simply don't come out of the box on agency and on intervention. On intervention, of course, if they had a direct and substantial interest, then the commentary in Erasmus that Malan who says the case law seems to suggest the court would not have a discretion, we would allow intervention. But once they don't show a direct and substantial interest, then there is a discretion for the court to determine whether the intervention should be done. Now, in this case, on the second requirement for agency level, they can get adequate redress in due course because once they report incidents to the law enforcement.
Well, as I said earlier, and I don't need to repeat the same argument that I put to Mr. Nkhuka Toby, is that the incidents that are relied upon in respect of the persons mentioned in the founding affidavit, they can be reported tomorrow, and a week or two can be given for investigations, and then they can come to court with an urgent application seeking mandamus for argument's sake. It's not a matter of waiting till December or next year, or because there's a lockdown or the road is full. But the point is, if nothing has been done in respect of those people that were apparently assaulted or injured, or even worse, then it's difficult to say, well, I'm going to associate myself with different relief brought by another party in a different matter, and I haven't even reported the ones that are my clients. I can't understand that argument.
Precisely, what raises is the role of the judiciary to ensure that obligations are fulfilled.
Yes.
So if they report, there is an obligation to investigate.
Yes.
If there is no investigation, they are entitled to come forward and say, direct these investigators to do their job. They have a constitutional obligations and they must fulfill that obligation. They don't even report any of those incidents, but they say that they come to court for the court.
And what does your client say that in respect of these three persons?
So we said the applicants, we invited the intervention intervening applicant in the affidavit that bring the details of the complaints of the fact, report them, they will be investigated. And if they then complain about delays in investigation,
Can I note that as an undertaking, that you will investigate that?
well, that comes from my client and is in the affidavit.
Yes.
Yes.
Well, there's a why I say that there's a reported case or a number of them that once a respondent gives an undertaking to comply with what you seek, you're not entitled to an interview.
Well,
So,
we have given them.
yes. So you will investigate that.
Yes, we will investigate.
Yeah.
Well, I could address the merits of the yes application, but
No, I'm not dealing with the merits at the moment. I'm still debating the intervention and the urgency.
perhaps I could let the remainder of my
I think so.
respond on this.
Yes.
So that parliamentary doesn't have to come back.
Yes, I want to hear who else has anything to say on this topic, and then I'll make a decision. Mr. Bofilatus, you are now for... Fourth and fifth. Right, what do you say on this topic, Mr. Bofilatus?
It's an issue which is slightly related or linked to the question of urgency, and that is the authority which we denied in our tablets. The authority of the intervener to bring the application, and then the authority of the proponent to the application, in fact, has signed over that. In the intervener's founding papers, there is a reliance placed on a resolution which is dated the 18th of April. And that resolution appears on page 39 of the application itself. You will see that the resolution was passed on the 18th of April, and it was a resolution in terms of which, inter alia, the entity resolved to join the court of family, I'm using the word now, in the urgent application of the Constitutional Court. The problem with this, of course, is that this resolution is dated 2 days before the Constitutional Court proceedings were commenced in respect of the problem. So, with respect, and this is not said under oath, that this was a resolution relied upon. I mean, one last aspect on the same issue is the element of whether or not in the new resolution there is in fact authority given to the person to dispose of that. And to that regard, I refer you to page 324 of the intervening application. And you will then see that the authority of the defendant supposedly to the affidavit on behalf of the intervening party brings to that defendant is missing. There's no evidence to the authority of it. Lord,
No reference to that particular person.
I beg your pardon?
No reference to that particular person. Right, so those are the resolutions that are defective.
It's a point in that Lord, but it is slightly related to the question.
Yeah.
I don't know.
Thank you, Mr. Bokolatos. Just a moment, Miss, you are for the sixth respondent. Just for the record, just give me your name again, please. Chabedi. What do you say on this topic? Yeah.
In the main application, the Ombudsman decided with the respondent, the main, there's no review assault against the Ombudsman, and the Ombudsman is not opposing file and installation affidavit, just to set out the mandate and other related issues which have been dealt with in that affidavit. Now, in respect of the intervening application, the applicant in this matter, now in respect of their trial, ask this court to grant specific interdiction in respect of certain areas which are specifically legislated and regulated. They are contained in the Military Ombudsman Act and the regulation. However, we deal with that, or rather I deal with that in the written submissions for the head of administration and compelled class in paragraph 22 to 25, and that relief we submit to be untenable. And that distinguishes between the issue of the argument about the same issues of law and fact that will be determined in the Khosa application, which would then benefit the intervening application. But the second aspect of our argument is on the practicalities and the facts. Members of the public whose complaints are mentioned in this application. None of them has approached the Ombudsman to report a complaint. In paragraph, in one of the paragraphs in the answering affidavit, we invite, because the Ombudsman received a complaint from one Lucky, and then in the, let me just refer your Lordship, just for noting, in paragraph 27 of the affidavit filed by the Ombudsman, we then state the following, that we've not received any complaint, nor are we aware of any complaint or incident implicating the three members of the public mentioned in the application by the intervening party, Mr. Senyani, Mr. Manyani, and Mr. Makubele. But we do have a complaint from a member of parliament, Mr. Mare of the DA, in respect of a certain Lucky. There is no surname. There are emails attached to the answering affidavit from the intake officials of the Ombudsman to Mr. Reinders, who apparently reported the incident to Mr. Mare. So now in paragraph 27, we invite the intervening party to indicate whether they're lucky that we know about, in respect of whom we're trying to facilitate an investigation, is the Lucky Makubele mentioned in their papers. There is no response. So my Lord, our submission in that regard is that, as it has already been submitted on behalf of the Minister of Defense, and he believes that the only intention here is to benefit from the agency already made out in the Khosa application, and some of the concession and the fact that in the case of the Ombudsman, there is no participation. Now the Ombudsman is forced to oppose in the circumstances where it would otherwise not do that because of prayer 12, which is untenable. And we submit in those paragraphs in my heads from paragraph 22 to 25, particularly paragraph 26, where we particularize why that prayer is untenable. That is the minimum of the submissions I make.
Yes, thank you. Is there any other party with any comment on this particular topic?
I beg your pardon, my lord, the IPIC is not, cited in the intervention application, and neither is there an order that is sought to establish an investigative mechanism that is like the IPIC. So the IPIC is not participating as the court presents.
Thank you. No other party then. Ms. Hassan, then that gives you a right to reply.
Yes, Your Lordship, please. Your Lord, insofar as the point of authority is taken, Your Lord, with respect, I must differ with my learned friends, Your Lordship. Your Lord, the Supreme Court has spoken on the point as to whether a resolution has to state that the person is authorized to depose to the affidavit. My Lord, in Haynes and another versus Telcom Namibia Limited, and after Your Lordship, reference in a moment to that. Striker J.A. held there is no merit in the contention that West Hayes AJ early finding that the proceedings were duly authorized. The finding affidavit filed on behalf of the respondent, the Lord, with respect to in my view, it is irrelevant whether Hunter had been authorized to depose to the founding affidavit. The deponent to an affidavit in motion proceedings need not be authorized by the party concerned to depose to the affidavit. It is the institution of the proceedings and the prosecution thereof which must be authorized. Lord, in the light of that, the submission on behalf of the Lord, and that decision is 2004, Volume 3, SA 615, SCA. Uh, 624 at paragraph 19, Lord.
Yes.
Lord, in the deponent to an affidavit is merely a witness, as pointed out by Striker. It is the attorney of the litigant who, by signing a notice of motion, issuing the papers, signifies that an attorney has been authorized to initiate the application. So, my Lord, the point with the greatest of respect, my Lord, is bad. My Lord, insofar as the military ombud is concerned, the position adopted by the military ombud is somewhat ambiguous, my Lord. Lord, here you have a person who calls himself a watchdog. And the watchdog says to your Lordship, instead of taking the position that I leave in the court's hands, this is my position, actively opposes the application for intervention. My Lord, when that is seen in the light of what the affidavit is, my Lord, the military ombud doesn't come out straight and say, I am opposing the application. What he delivers, my Lord, is an explanatory affidavit. My Lord, what is that? What does that convey? That is an attempt to convey an impartial position. Lord, but what this watchdog does, my Lord, and he calls himself that at paragraph 271 and paragraph 83, and hence the use of the words. He speaks with a forked tongue, my Lord. He says, I don't want to participate, and that's why I'm just filing an explanatory affidavit. And then, my Lord, he comes and he actively opposes the application. My Lord, with respect, the military ombud had to make a choice whether he wants to be in or out. And the Lord, having taken the ambivalent attitude, the Lord, it is surprising that the military ombud opposes the intervention application with such vigor and wit. It's a case of lady dog protesting, as your Lordship uses. Lord, insofar as Costa concerns, your Lordship is against us. My Lord, submit to your Lordship that your Lordship, unless your Lordship finds that the litigation was mala fide, submit to your Lordship it's not limited.
Thank you.
My Lord, we submit to your Lordship that there should be no order of costs against an organisation who acts in the public interest, my Lord. If there were to be cost orders under these kinds of situations, my Lord, civil society upholds the civil liberties, or tends to do that, my Lord, of those who don't have a voice, my Lord, will be discouraged from litigating. My Lord, if your Lordship will bear with me for a moment, please. My Lord, I have not, of course, not addressed your Lordship on the merits, but I understood your Lordship to address your Lordship. To address you on.
No, we're only dealing with joinder and urgency at the moment.
Those are ours.
And I will give a judgment on that topic. The Fair and Equitable Society seeks an intervention in the urgent application of Mr. Khosa and others versus the Minister of Defence and others, which I'm hearing today. The intervention application has been proposed by a number of the respondents, and in particular, having regard to the fact that I'm sitting in an urgent court and will certainly not give written reasons at any other stage, I find it convenient to refer to the fourth and fifth heads, respondent heads of argument, which deal with the questions that need to be decided when an intervention application is before a court. It is said that the intervening applicant failed to comply with the jurisdictional requirements for intervention, amongst others on the grounds that it has a direct and substantial interest in the outcome of the case, and has also not demonstrated that the intervening application is substantially based on the same facts of law as in the Khosa application. Furthermore, it is not urgent at all, and reasons are given. In the heads of argument, and I associate myself with simply to save time, as I've said, the opposition stated from pages 135 to 148. And I don't want to repeat, for obvious reasons, what was said there. What is also important is the relief sought and the basis of the relief in the intervention application. And the argument is advanced that some of the prayers sought are not dealt with in the founding affidavit at all. The Khosa application deals with its own facts and refers to the particular incident that resulted in Mr. Khosa's death and the assault of certain bystanders who are the applicants in the Khosa application. The persons who are purportedly represented by the party that seeks interventions are other persons, and much to my surprise I read that the assault on them, if I can put that just in general terms, has not even yet been reported to the Defence Force or anyone else for investigation. An important factor, in my opinion, is the undertaking given by Mr. Magnetti SC on behalf of the Defence Force that if the assaults on these particular persons are reported, they will be investigated. There are a number of authorities to the effect that when certain relief is sought and the opposing party gives an undertaking that it will act lawfully, alternatively not act unlawfully, the applicant party is not entitled to an interdict. Having regard to the mentioned considerations contained in the heads of argument on behalf of the fourth and fifth respondents, and my additional remarks that I have made, it is my ruling that the applicant is not entitled to intervene in these proceedings, and furthermore, that the matter is not urgent. It has alternative remedies at its disposal, including an urgent application which could easily be brought once the case has been reported to the Defence Force or other instances and no investigations take place. Nothing would stand in the way of the applicant at that stage to ask the court for an appropriate order, including a mandamus. The matter is therefore, in my view, also not urgent, and for that reason it is struck off the roll. No order as to cost is made.
As your lordship pleases.
Thank you, Ms. Hazim. Mr. Manetti, what is the time, by the way? I have no idea.
Yes, it's my turn to respond to Mr. Luka.
Yes, but what is the time now?
It's over, it's after 4, so maybe we could convene
Yes.
to commence with that.
I'll bring my watch tomorrow.
I beg your pardon, no. Come tomorrow.
I said I'll bring my watch tomorrow. What is the time now?
I think the mask is closing my ears, madam. It's 4:07.
4:07 already. Anyway, we achieved a lot today, thank you. Then the court will adjourn until 10 tomorrow.
Yeah.